Okay, happy Friday, everyone, and welcome to Tully Rinckey Land. My name is Carol Crossett. The presenter information is the slide before you. It relates to my curriculum vitae. I am a partner in the commercial and civil litigation and transactions, and I also practice in the area of trust in the states. So I'm involved in litigation work, transactional work, and also I practice in trust and estates related to trust and estate matters. I've had kind of a broad range of experience with that, and I emphasize that, including in my presentation, because of the fact of the topic today, which is CPLR 4519, known as New York's Dead Man Statute, and which makes attorneys tremble, including myself, because of the complexities involved. If you have any questions, we may or may not have an ability to answer questions. There's probably going to be a lot of questions. I don't usually like to answer hypotheticals within hypotheticals because it's missing factual, and this is a very factual intensive statute, and it can be very complex at times. Other times it's really it's a no-brainer when it applies, but we're going to kind of go through that, break down the elements and so forth. The overview is we're discussing the Dead Man Statute and its application. It's entitled Personal Transactions or Communications Between a Witness, and that's a party or person, we'll talk about that, and the decedent or person with a mental illness. Now, it used to be a person that was mentally ill. They changed the statute, but one note, and I might as well state it now, is we're not going to be concentrating or talking about guardianship proceedings. That's a whole different situation, and that involves usually like a communication involving a guardianship or some other proceeding. And I don't concentrate my practice in that, and that's, it's too broad-based. We have a lot to get through as it is. So we're going to be navigating the circumstances when the statute is invoked properly, and when it's invoked properly, to disqualify a witness, to render them incompetent to testify as against a deceased person or a person with mental illness. And we're also going to discuss in relation to that things like exceptions that are also in the statute itself, objections, waivers, and also I'm going to be doing an example, two of them, and hopefully we have time. And those examples, one of them is going to be a case that I was involved in. Another one is a case that's a recent case that will be discussed. And then if we have time after that, the criticisms. So we need to launch into it. So we're going to discuss what the list here, the elements and application, the purpose, why it was promulgated in the first instance, the interested witnesses who are the witnesses that want to testify, in which the protected parties, the protected class of persons, those are the persons who would be able to have standing to invoke the protections, and we'll find out who those persons are. The scope, usually this, we're discussing the subject matter. What type of proceedings this is involved with. It's broader than you think, probably. And exceptions and, the waivers and examples. So we copied the CPLR 4519 Dead Man Statute in full in here. When I look at this statute, I get a headache. I am not going to read through this statute. What we're going to do is parse it out instead, because if I read through it, by the time I read through it, 30 minutes will have gone by. It can be there's quite a lot of verbiage here. There's two sections, and there's just a lot to get through. So we're going to discuss that through parsing it out. And again, we will not be focusing on proceedings that involve a committee or guardian related to a person with mental illness. We might touch upon it here or there, but that's not what we're going to concentrate on. Slide 6 is what is the purpose of the CPLR 4519. But before I launch into it, what I wanted to do is provide like kind of a breakdown to keep in mind through the CLE. And one of the breakdown is the breakdown of the statute as it applies. As we've seen it in slide 5, it's a lot. but it applies upon the trial of an action or the hearing upon the merits of a special proceeding. It relates to a party or person who's interested in the event that they want to testify to, or a person from, and there's a lot of verbiage here, but person from, through, or under whom such party or interested person derives his interest or title by assignment or otherwise. The purposes of the statute is if they're interested, a party or person is interested, or a person upon which they derive their interest in through those persons or party, shall not be examined as a witness in his own behalf or interests, or in behalf of a party succeeding to that person's or party's interest or title. The persons who are protected class is the testimony must be made against an executor, an administrator, or survivor of a deceased person, or the committee, again, guardian of a person with mental illness. So it must be against those parties. That also includes a person deriving title or interest from or through a deceased person or a person with mental illness by assignment or otherwise. And then finally, the subject matter is they want to testify about a personal transaction or a communication between the witness and the deceased person or person with mental illness. So that's the breakdown here. So let's talk about a little bit about what the purpose is. And you've probably already figured it out. First of all, if the Dead Man Statute was promulgated because they wanted to prevent the possibility of perjured testimony against a deceased who can no longer testify. The deceased has died, and because the deceased has died, they cannot have the ability to refute the testimony or contest it in any manner. And it was designed to kind of protect and provide an adversarial type balance. It would be imbalanced if we allowed people to just testify with no ability about the other side to refute that testimony. Now, there's been criticisms related to that portion. We'll get to them, but that's the gist of it. If the testimony of the witness were allowed, there's no proper ability to challenge, or there's a limited ability to challenge, maybe through, another person who could testify. But it often is in the case, and we're talking about concentrating on deceased, the deceased would know more than anybody else about a communication or a personal transaction involving the deceased, and may know more than anybody else could know. So the ability of another person to testify to it would be very limited, if not impossible. And whether the testimony is true or false would never be discovered. And it would also be the case that the deceased could never help out in terms of determining the cross-examination of that witness, because the deceased is no longer around. There's always, especially in the earlier cases, but I think in every case that I've ever reviewed, this whole notion of fairness. And the statute is supposed to be applied with that notion in mind. Because if you only have the testimony of that person who wants to testify and they're interested, and that's why you have so many ifs and buts and ors in that statute, then it would leave their testimony and possibly nobody else's testimony to refute it. The other portion of this is the same as the case with persons with mental illness. Now, by reason of the fact, and this is the only point I think I'm going to make throughout this proceeding, by reason of the fact that a person has a mental illness does not necessarily render them unable to refute testimony if they have the capacity to do so, if they're competent. There are some mental illnesses, and I'm just stating that word because it's in the statute, that they would be unable to refute the testimony due to something very, very serious, perhaps. But that would require a determination about whether that person could refute the testimony or not for its application. So, aside from the need to strike an adversarial balance in these types of situations, let's go ahead and let's start examining the provisions of the statute. So slide 7 is entitled Witnesses Interested in the Event. And that's the witnesses that we're talking about just a few minutes ago. Party interested in the event, a person interested in the event, and a person from, through, or under whom such party or person that we're talking about derived his or her interest from. And it could be by assignment, it could be other ways that they derive their interest. So these are the 3 types of witnesses that may be disqualified as incompetent to give testimony on their own behalf or on behalf of a party succeeding to their interest or deriving their interest from them concerning a personal transaction or communication with the deceased or mentally ill person. And that, again, when such testimony is offered against the protected class of persons that I was talking about before, the executor, administrator, survivor, somebody who is deriving or succeeding to their interest from or through them. So in going through the witness's interest in the event, one thing that should be of note, a relationship in and of itself by blood or marriage to an interested party or person does not in and of itself make that relative, make that person an incompetent witness under 4519. It would be a number of different facts, and that's where you get into the factual portions of this about what they expect to testify to and their relationship, if any, to the transaction. If they are like jointly liable to a deceased person, or they were a joint recipient of a gift, that can be, of course, problematic because they would be interested in the event. But for instance, and I use, I think one example, like a husband could testify to his wife's meeting with the decedent, the deceased person, in which the decedent allegedly made an inter vivos gift of property to the wife. Now, just by reason of the fact that the spouse is testifying, the spouse is not interested. And we're going to talk about this and touch upon it later on. There's a difference between something that is a vested interest and something that is contingent or remote. And just by reason of the fact that there's a spouse involved does not necessarily mean that it's vested. And it's been found that it's not by reason of that fact alone. A husband could also testify, and this was in another case, regarding the wife's performance of services for a decedent who failed to pay the wife's services. And that was related to a claim, but the husband was not performing the services. The husband is not testifying on his behalf. He's testifying on behalf of the wife who performed them. And he's a disinterested witness. By reason of the fact that he's a spouse does not mean anything different. And I cited to Hammer versus Sitchin in there. If it's not in the materials, anything that I cite today, you can ask me about the case regarding, slide, whatever. But there's also another case called Platt versus Mitchen. And we'll talk about that case later, but that was a federal court case. The other one is a state court case. So there's another aspect of this, and I was going to discuss it more in length, but I'm not going to because it's very complex. But there's other statutes that can be involved with this application of 4519. And one of them that I wanted to touch upon very, very briefly, and the statute is very complex. So I'm not saying it applies in any specific situation or not, but by reason under the Estates Powers and Trust Law, okay, under 2-1.11, and there's different sections. There's paragraphs C, E, and F. By reason of the fact that a person who renounces a distributive share they're treated to be as predeceasing the decedent under 4519. And they would not be necessarily interested in the event, depending upon the facts, of course, but by reason of the fact that they renounced, they're not interested in and of itself. And that would be the same as a beneficiary, for instance. So a distributive share would relate to an intestate proceeding. And the reason for that is if they are renouncing the interest, even if they're testifying, there's a descent and distribution statute if you die without a will. That is by statute itself. So even if it would, by their renunciation, assist another distributee or increase that distributee's interest, that does not fit within the witness's interest in the event in most cases. And the same with the beneficiary. If there was a will and the beneficiary renounces their interest for whatever reason, it might be disclaiming it for tax purposes or whatever, but they renounce their interest under the will. If they testified, in support of the admission of the will, that does not mean that they are interested in the event, because they're no longer interested as a beneficiary in the will under this, hypothetical example, and they're not going to be gaining. They're not seeking to gain anything, and they're not seeking to avoid a loss. And the very fact that they're testifying about, admitting the probate to will, admitting the will to probate, does not mean that even if it's going to increase another beneficiary's interest or result in, a beneficiary obtaining the bequest, is not fitting into that, third a person from, through, or under upon which such party or person derived his or her interest by assignment or otherwise, because it would be by operation of the will itself, the terms of the will. And there would also be a section that is states powers and trust law. A reference to that is under 4-1.1. That relates to the descent and distribution statute in the EPTL that I was referring to when you have a distributee, because they don't have a will. So who are the protected class of persons who can invoke the statute to argue that a person who's they claim is interested in the event seeks to testify to a matter related to a personal transaction or communication with the deceased, and to argue that by raising objections, that this person should not be qualified to testify. They should be rendered incompetent to testify in the matter. Well, the testimony, again, must be against the executor, administrator, or survivor of a deceased person. And we already went through the guardians, so we won't mention that. And it also must be, or a person deriving his title or interest from, through, or under a deceased person. And I cited to matter of Petretti. That was a surrogates court, Queens County 2024 matter for that proposition. So those same persons who are a protected class, only those persons can invoke the statute. They can properly invoke it because they have standing. Parties that are not interested in the outcome of the decedent's estate, for instance, and this is an example in the case, cannot invoke the protection afforded by CPLR 4519. And we'll get to what constitutes a disinterested person, and also trying to introduce documentary evidence of if somebody is disqualified and rendered incompetent through a disinterested party. So I cited to Patterson versus Bowie, which was a New York County proceeding, and it provided that the protections of CPLR 4519 applied to a corporate defendant whose deceased president was a 50% shareholder, to bar that corporate defendant's testimony about the plaintiff's dealings because the estate at that point still held an ownership interest in the corporate defendant, and thus any judgment would be against the estate. So the fact that the plaintiff did not name the estate in the proceeding, and this is why I cited to it, the fact that the estate was not named as a co-defendant made no difference, because you can't plead out of this. If somebody were to argue that the estate has an interest in this matter, just because the estate is not named as a party to the proceeding will not prevent the proper invocation of the statute, if all of the elements are met, of course. So if the testimony involves a deceased officer, and this is the other example, or agent, a deceased officer or agent, but that deceased officer or agent also held an ownership interest in the corporation at the time of that person's death. And the testimony is, again, against the executors, administrators, or survivors. And the estate has an interest in the business in which they hold an interest in. The statute applies, and the estate or corporation can assert the protections against that party who wants to testify against a deceased officer or agent. But otherwise, officers and agents in and of themselves, if they don't hold an ownership interest in the corporation at the time, and somebody can testify as to communications they held with them, because they don't involve the matters related to the statute, a personal transaction or communication with the deceased against an executor, administrator, survivor. And they are just what they are, an agent or an officer. So if the testimony involves one who is merely a deceased agent or officer of the deceased corporation, that testimony would not affect any property derived from or through that officer or agent, and therefore it's not a proper invocation of the statute's protections. It does not bar testimony from disinterested witnesses in support of a claim involving an estate. So a disinterested witness can testify. A disinterested witness can also help with the authentication or laying foundation for the admissibility of documents in the event somebody who is an interested witness cannot testify, and because they can't testify, they have to try to introduce documentary evidence, business records, etc. And we'll get to that more. Also, another thing, and this comes up into the exceptions to the statute as they apply, is if an executor is not disqualified, an executor is not going to be disqualified by reason of the fact that they have a financial interest in receiving a payment of their commissions or a payment of distributions they made in relation to the administration of the estate. Commissions, first of all, are, statutorily prescribed by statute. That's one thing. It doesn't give them that financial gain, pecuniary or property interest. However, if an executor were to testify about an individual personal transaction, a communication with the decedent, for instance, if the executor had a claim against the estate related to the executor not in their position as executor, not for commissions or anything under a statute, but related to a personal transaction that they were involved with in the decedent. For instance, say, they gave the decedent a loan and the loan was not paid back in full, then they would be able to make a claim, assert a claim against the estate. And by reason of their status as an executor, that would not make them, necessarily, it would make them an interested party in that instance for a loan. But otherwise, their status as an executor in testifying about what they did or submitting an affidavit related to, some costs or administration of estates or why they should obtain commissions, it's not in itself would not invoke the statute. So it's first important to, just kind of go forward with the statute of what it applies to, just for purposes of repetition. This concerns a trial of an action or a hearing upon the merits of a special proceeding. This is a trial evidentiary statute. That's what it is. It bars and it becomes operative at the trial or the hearing upon the merits of a special proceeding. So that means pretrial proceedings. This doesn't apply to. And just because an executor, say for instance, calls somebody who could be an interested witness and calls them to testify, that doesn't waive the statute. It doesn't, and it also means that the bar for the admission into evidence of either the deposition testimony of that interested witness or the testimony itself by subpoena or otherwise at trial would be at the trial or the hearing upon the merits of a special proceeding. So what is a special proceeding? A special proceeding is pretty broad. It's a proceeding for relief specifically authorized by law. That's kind of broad. It's under the CPLR, and it's normally brought by a notice of petition or an order to show cause, for instance. We're not going to get into all these special proceedings, but the merits of the proceeding are the objective. In other words, an affirmative determination affecting the rights of any party is going to be decided. So it can be pretty broad. It can apply to the mental health hygiene law. We talked about, mentally ill persons and guardianships and so forth. Various proceedings under the Surrogates Court Act, probate a will, construction of a will, compelling a will, a proceeding to open a safe deposit box, a proceeding by a fiduciary to continue a business. It could apply to a proceeding by a fiduciary to discover property withheld or obtain information related to property or anything like that. But again, the notion is the statute does not apply to pretrial discovery. The statute does apply to civil proceedings. It could be medical malpractice proceedings and administrative proceedings. It has applied. It can apply to provisional remedies and injunctions. That's something that I didn't delve too deep into because I don't think I've ever had a situation involving that or not, but it depends upon really what the relief is. But pretrial proceedings, you can have examinations of attesting witnesses, attorney draftsmen, or pursuant to the CPA, certain sections of the CPA, including examination under 2211 of an accounting fiduciary. And, by reason of the fact of 2103, SCPA 2103, a proceeding by a fiduciary to discover property and so forth. As to the pretrial portion of it, it doesn't apply to the pretrial discovery proceedings. It's always operative, always argued at the trial. So you would waive it if you did not assert timely objections in connection with the trial or special proceeding. It does not apply to criminal proceedings, and it does not apply to any preliminary matter in which there is not a decision on the merits. If the testimony is offered under these situations, again, it's not a waiver of asserting it later on when it does become operative, and it's the time to assert the objection. So we're going to delve into motions for summary judgment, and I thought this was interesting because the statute applies to a movement for purposes of a motion for summary judgment. But it does not apply in state court to opposition to a motion for summary judgment by a party who seeks to maybe annex an affidavit, a transcript, or an interested person for purposes of creating an issue of material fact to defeat the movement. But the movement cannot rely on interested witness testimony or affidavits. For purposes of moving for summary judgment, they're seeking to gain or avoid a loss, and they are the movement with the burden, and it would be unfair to allow them to allow the statute, not to apply thereof. So it does apply to the movement. It doesn't relate it to the opposition, because what we want is the statute applies the trial, at the merits of the special hearing and so forth. So we don't want to, we want to allow the ability to have, for a person to have their day in court, for instance. So in state courts, it does not apply to opposition. And I cited to some case law inside the slide, and I don't think I'm going to go through it because it is what it is. But if you have any questions about it, please let me know. The federal court precedent, I wanted to, assert that federal district courts refuse to limit CPLR 4519's applicability to just the movement. It applies also to evidence opposing summary judgment, but that's a construct of the federal rules, and the federal court will exclude evidence under CPLR 4519, not only for the movement, but against the opponent, because the evidence considered on a motion for summary judgment, whether it's the movement or opponent, it has to be admissible at trial. And I cited, I believe, to Platt, I think you've got it in your materials, Platt v. Michan, 2023 case, and so forth. And what I wanted to mention about Platt, I think it was Platt. Yeah, I think it was Platt. There was a case in which the estate was involved with a case against for medical malpractice related to the decedent. And at that point, they requested depositions of the doctors related to the malpractice. The judgment would affect the doctors. So they would be interested parties, even though this was not, this is not an estate proceeding. It was a civil proceeding. And at the end of the day, the very fact that, and it bears emphasizing, the very fact that the executor and the estate sought these depositions of the doctors did not mean that they waived the invocation of the statute 4519 to bar the testimony at trial. In fact, they invoked it at trial, and the court found that, yes, it was properly invoked at that point, because the fact that they took these pre-trial depositions had no bearing. The executive could do that. It's pre-trial discovery, and the time to invoke the statute was properly made at the time of trial. And it ends up that their testimony, of course, was barred because they would be interested, because any judgment against them is going to be against them. There's going to be a loss. So they were not allowed to testify as to the communications with the decedent, with the transactions involved. Another proceeding I wanted to mention, and this is because this was in the commentaries, and it's really interesting about the possible unfairness of the statute and sometimes how it's very hard to apply. It involved in re Zalk. And I don't know if anybody's ever read this case, but an attorney had done a number of work for his clients over the years, some of which was billed, some of which was not. He was accused after the death of misappropriating client funds. And as a result, he was referred to a disciplinary committee. And the only party before him was a disciplinary committee. And he wanted to testify about the communications with the decedent related to those funds that were deposited in an account, and what the instructions were prior to death. And the disciplinary hearing allowed the testimony, but then thereafter there was an appeal taken. And the appellate division said no, because the CPLR 4519, he's an interested witness, and he's testifying about a communication related to the decedent who was unavailable to testify. So what happened is, as a result of that holding, it means the testimony, he was rendered incompetent. The disciplinary proceeding could not consider that testimony, not decide whether it's credible or not. They just could not consider it. And as a result, he received a 2-year suspension from practicing law, and it was imposed against him. There was a further appeal to the Court of Appeals as a result. They reversed the appellate division. And they did it on the basis of, you know, really applying the statute as it's meant to be applied. They decided that the testimony was not against the executor, administrator, or survivors. And even though it could have an impact against regarding them, it could have an impact regarding them because they would be the subjects of the decedent's estate, and perhaps it would impact the estate related to the funds that were in the account as property of the estate. But the Court of Appeals found no, the testimony was against the only party at the proceeding. It was the disciplinary committee. And the disciplinary committee is not the executor, not the administrator or survivor. And it reversed it. So there's a lot of maybe criticism back and forth, and in some sense, this was unfair by the appellate division, and the court recognized that because the disciplinary committee could always determine the credibility. And in fact, as I recollect, the disciplinary committee ended up, you know, finding this testimony credible. That he testified to, and it's a very long case, so I don't know exactly the specifics regarding it, and we don't have the time for that. But that's what happened. That was the gist. So it didn't have those. The testimony was not against the protected class of persons, and in a way, thank goodness, because they were able to reverse that decision, and it would have been unfair, I think, in that instance. For the attorney not to be able to at least testify, and if the disciplinary committee could always accept the testimony or not, or find that it was false or true.
The first course code is 156932. It's 156932, and I will leave it up on the screen for a moment.
Okay, great. Thank you. So the scope of protections, what are we talking about here? What kind of subject matter are we talking about, and the types of interests that we're talking about? So, you know, the testimony, it must be personal transaction or communication, as we've discussed. But the key point to remember here is the interest must involve a financial gain or loss, and we've touched upon that. If the witness wants to testify in support of admission to probate because they stand to gain by the admission of a probate of a will, or they seek to defeat a will because they stand to lose under the will, which another proponent seeks admission to probate. Either way, if they are testifying on their own behalf regarding a personal transaction or a communication involving that, that would implicate the statute. The type of interest, it's financial benefit or loss, pecuniary or property rights, and that's the thing to remember here. The witness stands to gain or lose. It doesn't matter. We touched upon one case involving a judgment. It can involve a judgment. It doesn't have to necessarily involve being benefited by an estate, either through a will or a will that they don't want probated because they're left out of the will, or related to descent and distribution statutes, because they don't want a will to be probated, because then they would seek to gain. So you have to have that benefit, looking for that benefit or loss. And you are going to benefit if you seek to testify that the will, you know, the decedent was not capacitated, for instance, and you had communications related to it, or a personal transaction, which you said there was another will in place, which hasn't been presented to be proponent, or that they revoked their will. Those types of instances that can crop up. And oftentimes it goes without saying, I think, as we go through this, that there are going to be cases that it's not entirely clear whether the CPLR 4519, you know, applies or doesn't apply. And the best advice, the practical advice, is to examine the statute on that basis, the elements related to same, and what the subject matter is, and so forth, the gain or loss that we're talking about, and protected class of parties, And there's a lot of times where it's so complex, the facts, that it just needs to be tested. And I would rather test something than, waive it. So it's like any other evidentiary rule. At trial, you raise an objection. Sometimes you're not entirely clear whether that objection is applicable. So you sometimes just have to test these things out. So we went back, we already touched upon this, but an executor who is the object of a bequest in a will, because oftentimes people name their son in a will, and the son will be the executor as well. So that when the executor, who's the object of a bequest in a will, or they're a creditor against the estate on their behalf, they would have a financial interest and become that interested party, subject to the application of an objection under the Dead Man Statute. Once the Dead Man Statute applies, one thing to make of note is that once it applies, it's not only personal transactions, communications, but it can go beyond that. If the person seeks to testify to something that is really just kind of it's an observance, but it is a testimonial in nature. For instance, they want to testify the decedent ripped the will right in front of them, or committed some other actions that they saw that are really testimonial in nature regarding the interest of a personal transaction communication that can also be precluded from testimony. So the point is here, and the hypothetical that I kind of introduced into here was a little confusing. I read it myself, and it was it was a little confusing. So I'm going to skip over that because that wasn't entirely correct, and we'd have to go into more complexities than I really thought. But the gist is that the interests that are uncertain, they're too remote, or they're contingent on something that hasn't occurred, those witnesses are not deemed incompetent to testify under the statute. It has to be something that is vested, a vested interest that has become present in order for that person to be deemed incompetent if the other elements are met. So by reason of the fact that a spouse of an individual who is interested in another individual estate, and that spouse is a deceased individual, that would not make the spouse interested to render the spouse incompetent to testify under the Dead Man Statute. And the way I worded it here was a little clunky, so I wasn't sure if it was entirely clear. But the gist is that even if the spouse would inherit if the other spouse died, because you can't disinherit a spouse, and they also have rights of election and all of that. At the end of the day, whether it's the spouse wants to testify to a deceased individual about an interest by their spouse in that deceased individual's estate, the fact is that the spouse would not be the spouse would not be interested because it would be contingent. First of all, if it relates to a deceased individual's estate under which the spouse claims he has an interest, it's contingent. Any spousal interest in that, if it passed to the spouse, would be contingent upon, first of all, the marriage continuing, nuptial agreements, other type of estate planning or size of the estate. And that's probably going a little bit too deep because it really must be, vested present. Okay, so we're going to talk about a couple of exceptions. We're going to skip over that quickly because we're running down and I'm already losing time. But some of the exceptions are right under the statute. For instance, a person is not deemed interested by reason of being a stockholder or officer of any banking corporation. So this applies to banking corporations. And the banking corporation is a party to the action or proceeding or interested in the transaction or communication. That's directly under the statute. Also under the statute is a witness is competent to testify about the facts of an accident. We're talking about the facts here. The facts of an accident can involve a motor vehicle, aircraft, or vessel. it involves claims of negligence or contributory negligence. And involves an action where one or more parties is the representative of the deceased or incompetent person, as the case may be. However, this does not permit testimony as to conversations with the deceased about the accident. So if somebody wanted to introduce, like, oh, the deceased told me he caused the accident or contributed in some manner, that is barred by the statute. And this is another one under the statute. A party or person interested in the event shall not be disqualified either if by reason of the possibility of imposition of costs or like an award of costs to them. And the reason for that is plain. That has nothing to do with what they want to testify to about a personal transaction or communication. The imposition of costs also could be awarded under a statute, under a contract, and so forth. So that doesn't have any bearing. Other statutes provide exceptions. Again, we talked about this before, but this one in particular is EPTLL 5-1.1A. That relates to the right of election or an elective, which is the elective share of a spouse. And that surviving spouse is accepted, that they may be able to testify because they're not considered a person interested in the event, and they can testify regarding the deceased contributions to jointly owned property, for instance. That's the hypothetical. And the reason for that is right under the statute. It is the spouse's burden under the statute to establish the proportion of the deceased contribution. And that relates to determining a net elective share and other issues under the statute. And below that, and I think that I cited to that Brzezinski case. The Brzezinski case was a case in which the executor did not waive the bar at trial just by reason of taking the party's deposition. So that was actually the Brzezinski case. It was 4th Department, 1982. If I don't have it in the slide, and I may not, my eyes are really bad and I have like 5 pairs of glasses. I only have 2 with me today. Then certainly you can follow up for case law. So we're talking about what do we do if a witness is interested? Say we're representing the witness, not the executor, survivor, or administrator, but the witness who wants to testify, and they've determined to be an interested witness. Well, there is the possibility of introducing documentary evidence. That would not be immune from objections, including objections to admissibility into evidence. But anything, and one thing I might point out is if a person is deemed interested witness and all the other elements are met, if the bar of the application of the statute, if they are barred from testifying and deemed incompetent, you cannot resurrect it by saying there's an exception under other hearsay exceptions. If the Dead Man Statute applies, it applies, period. And this relates again to testimony. So what do we do for documentary evidence? So the documentary evidence would require, of course, authentication and laying a foundation at trial, but it would require it to be determined by a disinterested person in order to be admissible. That's the way to go around it. You can't have the testimony of the interested person who is deemed incompetent to testify try to introduce documentary evidence and also authenticate it, because that again would fall under the statute, and we're trying to strike an adversarial balance here, and that person is deemed interested. So we need somebody who's disinterested, somebody who's not interested in the transaction or communication, who's not going to be receive any financial gain or prevent a financial loss or pecuniary loss. And the same goes for business records. It may be possible to prove the transaction through business records. And that's really the same, case. You would do it through a disinterested party. And I cited to the Trotty versus Estate of Buchanan, in which, it ruled the court ruled that a grocer could lay the foundation for, the business records that she creates in the normal course of business, reflecting credit extended to the decedent, because the manner and method of how she reflected transactions in her business records in the normal course was not deemed to be an act of independent of the transaction or communication with the decedent. Of course, she still couldn't testify to anything related to communication about those with the decedent, but it was just for purposes of the business records. Introducing former testimony, it is possible. It might fall into an exception to hearsay, and also you have the unavailability provisions. So it would also, if there was a case in which it involved former testimony in which the deceased was involved with, and they were able to participate in that former case, and also obtain cross-examination of that witness, it could be introduced. So I cited to Siegel, and we won't go through it too much, but the point made was that the pretrial deposition of an interested party qualified for admissibility against a decedent's estate. And the reason for it is the decedent had the opportunity to not only participate, but the decedent himself or herself actually conducted the examination of that witness. So they were subject to cross-examination. The other point to make here is that the decedent testified in that former proceeding and was subject to cross-examination and all of that. Then that could be another way of introducing former testimony.
So the last code is 738196, and it's 738196.
So the standing to raise the objections and the burden, it's going to be, the standing is, again, on the protected class of parties that we talked about. And that's those persons are going to also have the burden. If those same persons were suing, the decedent's estate on their own individual behalf, this would, of course, not incorporate standing, nor would we probably have an issue on that. So the waiver of the statute's protections, persons protected by the Dead Man Statute, same persons who could deliberately waive the protections or inadvertently waive them. They are waived if they are not raised at trial. Pretrial does not matter. And any waiver would be limited to the specific transaction or communication testified to. It would not broadly encompass other personal transactions or communications. However, I could envision a case where those transactions, communications were so embedded in the other personal transaction that you could have an argument. And I'm sure that you would have an argument in relation to whether they would apply as well. So it's got to be timely asserted, and the time to assert is the trial or the hearing of the special proceeding, and to raise that, and also including an motion. I believe that sometimes it's a way of strategy to bring it up beforehand, even if it's premature. But it's really dependent. This is very fact intensive. It would require an analysis and strategizing about what would be, when it would be raised. But for purposes of waiver, you have to waive it before that time. You have to assert the objection. You waive it if you don't by that time. If it involves several persons, the waiver must be made by all of those protected parties, not just one. And the waiver, again, of one transaction would not apply to other transactions or communications. So it would be separate for each transaction. It could also occur if a protected person testifies about the transaction or communication on their own, but again, it has to be on their own behalf to open the gate. If it's not, then that doesn't open the Dead Man Statute. We're getting to the hour, so I'm going to go quickly through this. This was a case that I was involved in. The case that I was involved in involved a individual who sued my client in a business. And the gist of the lawsuit was essentially that they had a interest in the business that was in connection with a verbal agreement that they had with the deceased. The deceased was the father of this individual who was the successor in interest owner of the business. And they were also the person who derived their interest in the business through the decedent. And the gist is that the individual plaintiff was claiming that he had verbal agreements with the decedent, who was, of course, unable to testify. And also he asserted certain claims against the successor related to claiming to have the same verbal agreements. He also claimed that he undertook certain actions in relation to the verbal agreement that upon the death, he would obtain an interest in the business. So as a matter of strategy, I argued for the dismissal of the complaint, basically arguing that the entire complaint was going to be futile because it was going to rely primarily on only this individual who had communications regarding a personal transaction related to a business with the decedent. It was going to be made because the estate had an interest in the corporation. The estate actually was outside the state of New York, but the business was in New York. And I argued that this was futile and that the case should be dismissed because if it's the testimony is going to rely on him, and he had no disinterested witness that was involved with this. And he couldn't testify to communications related to the successor either, because the successor was also the survivor and also derived their interest in the business through the decedent. So I argued for the dismissal of the complaint about this promised partnership interest. I argued that it was futile. He would be incompetent to testify to the transaction and communications he wanted to, and that if he wanted to introduce any evidence related to the actions he purportedly took in relation to the purported partnership interest that he was promised, that he would not be able to be the person authenticating or laying the foundation for it. So I cited to several cases. The gist is that the testimony, the documentary evidence, it was going to be entirely reliant on this person who was an interested party. And it was certainly interested because he stood to gain if he obtained a partnership interest, and certainly it was made against the estate, who was not a party, by the way, named in the proceeding, but the estate held an interest in the business, and as did the survivor. So ultimately, a conference was held with the court to discuss the motion, and ultimately the party agreed to discontinue the action and file a claim against the estate if they intended to proceed with their claim. And the reason for that is I believe that they wanted to avoid facing the consequences of a possible decision on the motion, which it was clear it was probably not going to go very favorable for them. So they dismissed the proceeding against the client in the business. I understand they did file a claim against the estate. The estate proceedings were quite lengthy because it was a large estate. But one thing of note is the estate proceeding was outside New York, like I said, and the state where it was in a state in which the state had prior to this repealed the Dead Man Statute, but they did have a statute in place related to limiting certain statements made against a decedent in connection with an estate. And I understand that I don't think it's settled in this party's favor, but that's kind of what I wanted to express. I didn't get to the recent case, which was decided on June 2nd, 2025. If anybody's interested in reading that case, I can certainly send you the citation. I didn't get to the criticisms, but I think that we kind of know what they are and are not, that there's other ways of possibly discouraging perjured testimony by reason of the fact of sanctions even criminal penalties, and the fact that of cross-examination, the ability to conduct cross-examination and to have other witnesses. So there's been a lot of criticisms against the dead man statute. A lot of people complain that it's led to inconsistencies, and it has. I've seen it myself, and it's very complex, and sometimes it makes you scratch your head about how the ruling ultimately came about. So that's part of the criticisms, and I think that's probably a major one, is some of the controversy with the inconsistent decision making in applying the statute. All right, so I hope you had fun because the dead man statute is always fun. I'm sorry I went over. Please, you can send your questions to me, and if I can answer them, I'll certainly answer them. I do respond to emails, so don't be shy. I hope you did at least enjoy or learn something. We had to go quickly. We had a lot of material. We got through most of it. So thank you very much, and the rest is in the good old slide that you got, the presentation. Have a nice day.